Do you find yourself dreaming of breaking away, but worried that everything you've built is captive? Did you sign a partner agreement years ago that now feels like a trap? Has your firm sold out to an aggregator or a private equity buyer, and suddenly the trajectory that you envisioned is now gone? This episode is for you if you've ever looked at your contract, your firm, or your future and thought, am I stuck here? Today, we're going off script with Andrew Shedlock, an attorney who knows this space exactly. He knows how the contracts work, where they cross the line, and what you can do if you're ready to walk but afraid of what's in the fine print. Welcome to Advisors Off Script. It is so good to have you here. Welcome to Advisors Off Script, stories from the independent front lines. I'm your host, Shelby Nickel. Andrew, welcome to Advisors Off Script.
Thank you, Shelby. It's nice to be here, and I appreciate your time.
It's so good to have you here. And I want to start us out with what I see as sort of like the big looming question that we hear from advisors every time that we talk about a transition. And the question is like, can I even leave? Somebody's been with their RIA for years, they've signed a partnership agreement, they've served clients well, but now they're feeling a little bit trapped and probably scared. What is your response to that advisor?
Shelby, my response to that advisor is almost always yes, you can leave. It's just a matter of how difficult will it be for you to leave, and what do we need to do to make sure that you can leave? Because I think you're right. We're seeing a whole new generation of advisors who have worked with RIAs, independent RIAs, wirehouses, what have it. And like the previous generation before them, they've built their books, they've developed these deep, lasting relationships with clients. And that as we know well, as you know well through your work with and for advisors constantly, there are so many options for advisors now, so many different affiliation models, so many ways to go out on your own. So yes, you can leave. It's just a matter of how hard is it to get out. And I think a lot of advisors come to me, for example, and they say, I've got this contract. You know, I don't understand everything in it, or I understand some of the scarier words. What do I need to do? So you can always leave. It's just a matter of how long do we have to prepare and how much work are you willing to put in to make your transition successful?
Yeah, I think that's a really good point because it does take preparation and we want to always, make sure that we're sort of staying in the guardrails that our legal counsel gives us. And I can tell you, like with our clients, I don't like to take on unnecessary risk. I want to be practical about it. I don't want to be scared of the covenants because I don't want people to feel trapped in roles and workplaces that aren't serving them well. But we also wanna be practical and we wanna be strategic and we wanna be careful, right? Like, we don't need to take on excess risk. When you think about the clauses that you're seeing in in contracts these days, and I've seen things like non-solicit and non-accept or non-service, can you kinda talk us through some of those kind of restrictive words and what they really mean? Can we kinda start there today?
Definitely, Shelby, and I think you're right. In my practice, I generally counsel advisors to comply with their agreements. I mean, I think you can make a successful move as an advisor while strictly complying with the terms of your agreement. So you brought up some good words: non-solicit, non-service, non-accept. I'm going to add one in there, and that's liquidated damages as well. We're seeing those clauses pop up. So let's handle them one by one. Non-solicit is going to be in essentially every financial advisor contract. And truth be told, that's one of the easiest to comply with. Now, what does non-solicit mean? It essentially means, based on the wording of the agreement and the specific state law that controls, that the departing advisor cannot solicit his or her clients after or before he or she leaves their respective firm. Now, the word solicit means different things in different states, of course, which is why you need to review your state law. But generally, the word solicit in terms of these transitions means to make an urge or a plea or to ask the client to do something. A lot of the times, these contracts will define solicit as barring some sort of contact that the advisor initiates. For example, the advisor cannot call client Susie Smith after advisor has left the firm and say, Susie, I'd love for you to come join me at my new firm. I mean, textbook solicitation. The trickier question for my clients and advisors in this space is, well, what if Susie Smith calls me after I leave the firm. Or even better, what if I call Susie Smith, don't tell her that I want her to follow her, but I tell her that I've gone to a new firm? The classic announcement theory. I'm going to call my clients after I leave using publicly available information and tell them that I'm no longer at X firm, but I'm at Y firm. Is that solicitation? Now, obviously, we're time limited here. Every state has different meanings. Some state courts say that the announcement call is really nothing more than a solicitation that's initiated by the advisor and intended to have the client say, well, how do I follow you to your new firm? Other states say, no, the announcement is simply you're announcing a change of employment and nothing more. So that's why, you know, reviewing these clauses early and not scrambling at the end is important. You mentioned a few other ones, non-service and non-acceptance. I'm seeing a lot of these non-service and non-acceptance clauses in independent RIA agreements and private equity backed RIA employment agreements. These clauses purport to say that an advisor, regardless of who initiates the communication, whether the client or the advisor, cannot accept or service that client that wants to move firms. Perfect example. John Smith is an advisor. He leaves his firm, goes from firm X to firm Y, and client Chris calls up the advisor and says, "I'd like to follow you." Well, the advisor, if he has a non-service, non-acceptance clause in his contract, is supposed to say, under the terms of that contract, I can't work with you. Even though you reached out to me and I've had no contact with you, I can't accept your business. And I've actually written a few articles on these subjects because this non-service, non-accept is becoming more pervasive. Some courts are starting to treat them a little more harshly and saying that's really a restraint on trade. It's against public policy. So we'll have to see how that develops a little bit more. I mentioned liquidated damages too. It's another provision in these agreements where firms, rightfully or wrongfully, purport to say that if you do accept or take business from a client that was at this firm and you work with them at a new firm, you owe the firm two times their annual revenue, three times, four times, six times, whatever it is. And that's really a state law analysis too, because some state law says that, well, those are really penalties that are meant to discourage movement and not necessarily, proper liquidated damages. But we're seeing that trio of clauses in the private equity backed firms and in the independent RIA space more and more.
Yeah, it's super interesting because I think about, a liquidated damages clause, if it's 2x or something, I think that's actually kind of okay personally. Like if you want to take that business with you and it's essentially kind of a buyout clause at that point and you know what it's going to cost you to take those clients with you. A non-accept, non-service clause feels like it's really limiting client choice more so than just impacting the advisor. All for client choice. I'm all really for advisor choice. And so those would definitely be two clauses that I would encourage people to really try to push back on. It can be really hard though. You've joined this RIA or this firm when you were maybe out of college in your 20s, you're coming up the career ladder and you maybe didn't even know that at some point in time you would want to be an advisor entirely on your own or be an advisor at all, and now you have this client set that cares for you and the environment isn't great, right? So this is such a tough one. I see it from both sides, the ownership viewpoint as well as the advisor's viewpoint. Um, so what are your thoughts about, like, as somebody is coming up the ranks, can they push back on these clauses? Do you see that being successful in any of these work environments?
Shelby, you can push back on these clauses, and I think you hit the nail on the head. Is that there's a tension here, right? You have these advisors who were young, started out maybe with a handful of family clients, but the advisor, he or she, is pounding the proverbial pavement and really gathering more clients. And the firm, of course, is providing support, employment, technology, office space, all sorts of things to these advisors. However, am of the firm belief that generally, not all the time, but generally, clients hire and want to work with advisors, not necessarily firms. I mean, you want to work with someone who knows your kids, who knows your grandkids, who knows your plans, and that comes through the advisor centric relationship. Again, that's not to say that the firm has nothing to do with it, but I think when push comes to shove, the reason that most clients transition with their advisors is because they have a deep sense of kinship to that advisor, not necessarily to the firm. And so I do have clients come to me and say, "Hey, I have this liquidated damages clause in my agreement. I'm not up for litigation. I know my firm likes to sue people. I know that when push comes to shove, I don't want to deal with a TRO and years of litigation. Can we negotiate this?" Most of the time, yes. I mean, most of the time you can negotiate an exit, a buyout, like you discussed, where you're essentially buying out a few years of future revenue of the clients that will just naturally follow you. I mean, if that number is 6, 7 times, maybe that's not possible. I don't know a lot of advisors that have, 8 times their annual revenue just sitting around for a buyout. That being said, that's why it's important to know what kind of firm are you leaving? Is it a smaller independent RIA? Is it a bigger private equity backed RIA? Do they like to sue advisors? Do they sue advisors on merit, or do they sue advisors just to make sure other advisors won't leave? And so
Yes.
that's why it's important to work with someone like yourself, Shelby, someone who knows this space inside and out. A great person that understands where this industry is heading and what's really best for advisors and clients.
Really appreciate your, conversation there about like it's really important to work with somebody, and I want to return the favor and return the compliment. It's really important to work with somebody like you. And one of the things that I have really admired about your personal work, Andrew, is you're one of the few attorneys that I see that are really commenting a lot often on the state law aspect. Can you talk about how the states, maybe by, like which states are the worst, and I think California maybe is one of the better states, and if you're an advisor in California, lucky you, because of their rules. But, talk about your review and what you're doing at a state level.
Definitely. Well, thank you, Shelby. And you're right. I mean, California is a very pro worker, pro movement state. Other states, Florida is one of those states where non competes, which we haven't really discussed because they're not really relevant in this space anymore. But Florida is one of those rare states that's making non competes more enforceable under statute, under law. I'll give you a great example. Let's take a state like Georgia. Now, Georgia has looked at these and has great case law on these non service, non acceptance clauses. And again, we discuss with these non service, non acceptance clauses. Well, the firm says that even if the client comes to you and you did nothing to help that client come over, you didn't initiate contact, you can't accept that client, you can't service them. Well, there are multiple cases in Georgia where a large private equity, unnamed uh, RIA sought to enforce these non service clauses. And in their contracts, and these are all public cases, in their contracts, this RIA says that you may not accept the business or service clients or something like that, whether or not the business was solicited or unsolicited. That's a summary. Georgia courts in these opinions will literally go in and cross out the word unsolicited and allow advisors to accept and service the business of unsolicited clients. Now, solicited business, no court's going to bless that. But Georgia courts will hammer away at those non-service clauses. Other states, New Hampshire, Massachusetts, tend to honestly support these non-service and non-acceptance clauses, which is a bit surprising to me.
Yeah, I was just gonna
Illinois,
say that. Yeah.
yeah, Illinois will find them violative of public policy. So if you're an Illinois advisor controlled by a contract under Illinois law, you're likely to be able to invalidate that clause. Other states, like my home state of Minnesota, there's no clear state law at this time on whether or not a specific non-acceptance, non-service clause is valid. So it really does come down to understanding that if I'm an advisor in Georgia, my transition may be a lot easier. But if I'm an advisor in a certain Northeast states, maybe I have a little more problems to figure out. And I think that's why it's important to kind of keep your pulse on the industry and understand, again, who sues, why do they sue, and what can I do as an advisor to prevent that? Because we can't change the terms of contracts, but we can certainly control our actions, before and after our departures.
Is there anything that you would suggest advisors do in order to discover what their state law is? I mean, obviously they're going to need counsel, but I know also we have a lot of advisors who like to do a little bit of research on the front end. They're going to need counsel. We want them, you have been tracking this for so long that I know you're an amazing resource. Is there anything else that they should be doing to check state law?
Yeah, and one of those things, obviously, to track state law, you really just want to read sources like CityWire or other organizations out there that really track lawsuits. I mean, some of these newsletters keep a great thumb on the lawsuits that are getting filed every day. Talk to someone like yourself, Shelby, because your clients are seeing things and coming to you with things that isn't public that we just don't know about. And so, yeah, outside of counsel retention, I mean, go talk to someone like you who knows what's going on here, who understands what's being said behind the scenes. And when there is a lawsuit that involves your firm, for example, if you're an advisor, I mean, go pull the public records. That's one of the great things about these suits is most of the time it's pretty simple to go find the complaint, see the contract that's being litigated, and see the response. And again, there's no secret. There's nothing private about that. It's just more understanding. Okay, this firm says that announcements are violative of public policy, or announcements are solicitation. Okay, well, if I'm an advisor and I make an announcement when I leave, I should probably have a greater than not chance of getting sued.
That's right. One of the things that I also wanted to ask you is a moment ago you mentioned, and it caught my ear. You mentioned around private equity backed RIAs very specifically. And what I've been observing is sometimes that they're feeling a bit more like wirehouses these days. It's been so interesting to me because I grew up in the broker dealer side of the world, right? And growing up in the BD world, right, wirehouses were bad, regional firms were good, independent broker dealers were maybe good or bad, it depended on your kind of viewpoint. In the RIA space, it's like everything broker dealer is bad, RIAs are always good, right? And yet I'm seeing these like super restrictive clauses like we were just talking about coming out of the RIAs, and you mentioned private equity backed. If my organization announces that we're going to be acquired, what should I start to think about and do at that time?
Definitely, that's a great point, Shelby. And I think the financial advisor antenna should go up if there is discussion of an acquisition. Not to say that the acquirer is bad or the firm backing the acquirer is bad. It's just you do see these more restrictive clauses in private equity backed firms. That's one of the only places you see a non compete clause, really. It's tied into an equity grant. So, as an advisor, before I sign anything with a uh, with a private equity backed firm, I want to make sure that's reviewed thoroughly so I understand at least what I'm getting into. If there's talk of an acquisition, that doesn't necessarily mean it's time to leave. It just means it's time to really consider your options and what you want to do going forward. Because once those transactions happen, I mean, the lifeblood of these firms is client and advisor retention. Because we know that clients stay when the advisors stay. When the advisors leave, the clients generally leave too. And so, it may be a good time to fish or cut bait, but it's definitely a good time to perk up and say, we're going to get some real professional agreements here because a lot of these smaller RIAs may have agreements that, were drafted decades ago by, less sophisticated parties, but these private equity firms are not going to have that. So you have to be up for the challenge of understanding what you're signing before you get into it.
Yeah, I think that's a really good point. And I think about it when sometimes when these firms are being acquired, even before they start to like kind of go for sale, you might see your leadership pushing out some new agreements to you. And that could be an indicator that your kind of founding partners, if you will, of the practice of the business may be looking into selling because they may be wanting to have some documentation around the security of those client relationships because that's going to add to their exit price. And then once the PE buyer or the new buyer has purchased, there's absolutely gonna be probably I shouldn't say absolutely, I can't say it 100% of the time, but 99% of the time, there's gonna be new agreements for you to sign, and those handcuffs, those clauses are probably going to be more restrictive than the prior firm that you had in place. And so, to your point, Andrew, it may not be the time to move, but it's definitely the time to start thinking about what do you want your actual future to be? Do you want the ability to have your own practice at some point? Do you want to have ownership of your book of business or not? Is that important to you or not? And do you want to be in sort of that business owner chair? If you ever want to say yes to those questions, like we don't want to sign anything that's more restrictive than what we have today. And so it could facilitate a need for some type of move. Do you agree with that, Andrew?
I do. I do. I think you're totally right, Shelby. When new agreements get put out there, as a firm, I would do the same thing. I'd counsel my clients to say, "Hey, we need to lock in our assets essentially, and make it more difficult to move." And few advisors are really up for hankering for a fight and a litigation to move. I mean, they want to move, and most of the advisors, if not all of them that I work with, and probably you see this too, they want to comply with their agreements to the absolute best of their ability. Some of these provisions are unenforceable under state law, but most of the time you can say, okay, these are pretty onerous, but I can do it because I'm a great advisor who has these deep personal relationships. So when you see those new agreements come out, it is time to call someone like you, Shelby, and figure out, okay, if I'm going to make a move, maybe I don't want to move, but maybe I have to move now.
Mhm. Yeah,
And
it
that is
could be your choices are essentially kind of, to your point, kind of being taken away, right? Like, this is a catalyst. It might have pushed us along into something that we really weren't comfortable for, but we also have to protect ourselves in this future new world where these new clauses could be really hampering.
They can, yeah, they can, and it's almost like we went from this world that was restrictive on the broker dealer side to this RIA world, like you mentioned, that was very kumbaya, fiduciary duty, and then it kind of flipped to saying, well, we don't have the same FINRA rules on the RIA side as we do on the BD side, so let's impose some restrictions on advisors that we honestly can't. I mean, you can't do non-service, non-accept on the FINRA side. I mean, in fact, you have to do the opposite. If you're a firm and your advisor leaves, you have to go tell the clients at that advisor where that advisor went to. You don't have that same prospect on the or that same requirement on the RAA side. So we are in this new world, and as both is we were on the advisor transition and pro advisor movement side. Again, I think the rule is you can comply with these agreements and still move your book of business. It's just about making sure you understand the effort and the push it takes to do so.
Yeah, I think that's you're right, and it's interesting. You're going to have to understand what is the effort and the push that you need, or that is going to be required to move. It's interesting if I think about the first part of our conversation today and talking about non-accepts and that they can be enforceable in some states and not in others. Like that point of time when you become aware of a pending purchase or a pending sale rather of the practice that you're affiliated with, like that's when you've got to dig into that state law and understand what your rights are going to be long term. Because hopefully you can just stay where you are. If you're happy there and everything, hopefully it's going to be okay. But the environment is going to shift as a part of that process and of that purchase. And, that kind of thinks makes me think about just in general, we see over time as firms grow, obviously the environment in those firms also changes, right? We've gone from maybe a 3-person practice to now we're a 10-person. Well, that's going to be a different cultural feeling than the 3-person was. Or we were at 10 and now we're at 30. Like that's going to feel different. If I have freedom, what is my requirement to sort of notify my employer? So let's say I don't have an agreement or I do have an agreement, but it's pretty lightweight. Do I have a 30-day notice period? Is it a 2-week notice? How do you counsel advisors to think about departing from one firm and joining another?
Yeah, I mean, I think again, you hit the nail on the head. It's really following the terms of the contract. Some of these notice provisions are a little stronger or stricter than others. I mean, some agreements have your traditional garden leave where you announce you're leaving and then you just have to sit there for 90 days while your firm tries to secure your clients and you can't leave. And if you leave without, providing the proper notice, that's another avenue for your firm to see you. But again, I think it really goes back to, you could have a 90-day notice, a 30-day notice, 7-day notice, whatever it is, but your transition will only be as successful as your practice has been over the last decade. If you're a really good advisor who picks up the phone, is working with your clients, who builds those meaningful relationships, you really shouldn't have much to worry about because the chances of a firm principal swooping in and trying to connect with your clients, after you leave or as you're leaving and convincing them to stay, that exists and they're going to try. But most of the time, what I see, what I think we see in our work is that the clients follow the advisors. And so again, there's no need really to go break these contracts and say I'm going to go solicit and call clients when that's prohibited. I mean, you can do this and comply under state law. The more aggressive you get, the more likely generally you are to get sued. And if that's a risk you're willing to take, so be it. But the timing of your actions are important. And that's what I think one of the things that advisors really need to know, like we discussed, we can't control the terms of our contract that we signed 7 years ago, 10 years ago, locked in stone. What we can do is control our pre-departure and post-departure actions. We can make sure we don't take confidential information. And once we leave, we can make sure that we are communicating with clients in the proper way, where we're not soliciting, whatever solicit means under that proper state law. And so that's why, you game those situations out before you leave. So once you leave, you can hit the ground running.
Really appreciate that idea that the only thing that we can control is what we do in the planning stage and also after. We've already signed our agreement. We're already sort of stuck with the terms of it. When you think about preparing for a change and for a move, what is some of your core advice that you give to advisors? And obviously it's going to be dependent a little bit on their agreement, but let's take a situation where somebody has a non-solicit, they don't have a non-accept. What is some of your guidance in that non-solicit environment?
Yeah, in those terms, non-solicit, of course, means different things under different states. But generally, a non-solicit, you want to refrain from, if contractually prohibited, you likely want to refrain from initiating communications with your clients that are urging them or making a plea to do so. The exception to that may be an announcement strategy where advisors like to call their clients using publicly available information. One thing we discuss with our clients during a transition is what likely is going to happen is that your clients are going to reach out to you once the firm notifies them that you've left. What can I say to those clients once they call me? And we have a whole process we go through based on your contract. And every contract is different, every state law is different, but generally you can answer their questions and you always want to be truthful. That's the main thing is you always want to be truthful and honest. You certainly don't want to bash or say negative things about the firm you're leaving, but at the same time, these are conversations where clients will have lots of questions because you control and manage and have managed a lot of their money and their life savings. So, a dark of the night transition announcement is quite jarring to a lot of people, especially if you work with a lot of retirees. So, the amount of questions you're going to get, you should be prepared for. And then, really, making sure the kind of information you're using to communicate with your clients is compliant. I mean, there's certain information you can and can't take when you leave an RIA. Most of the information is client confidential information, and you simply can't take it, and you should purge it. Inevitably, there's things that's borderline. How do we use social media? I'll give you a great example. Some private equity backed firms specifically have a contractual clause that specifically prohibits indirect announcements to clients over social media. Other firms will require that their advisors, break LinkedIn connections or Facebook connections with their clients. Now, to my knowledge, these haven't been necessarily challenged in a lot of states. So I do wonder if something like you can't post on LinkedIn if you have a client connection, whether or not that's enforceable. But I am surprised more firms don't try to prohibit an indirect announcement, for example.
Yeah, I don't know that maybe people thought they should. So I kind of wish we hadn't let that cat out of the bag.
Well, it's out there. It's out there.
It's
Yeah,
out there. Yeah. I mean, because that's a good point, and that is a big part of a non-solicit announcement strategy is, making sure that you have all of your people on LinkedIn or your Facebook page or wherever it is to where you can make an announcement and it's not a direct solicitation in any way. So, very interesting to think about firms are starting to close that maybe that gap or that hole, if you will.
definitely. Definitely. And you probably see this, in your work too. But, if you're an advisor, I know you've told me, Shelby, that one of the things that transitioning advisors need to have on day one is a really good website.
Yes.
And that's a non-negotiable, and I completely agree. Especially if you're an advisor with a more common name or more common last name, you need an even better website to drive that traffic. If you have a less common name, your clients are inevitably going to Google you, and you want that website and their phone number to pop up right away. So I think you're totally right that that website, and I know lots of people. that you can make these great websites. It's really important you have that day one because those first 30 days are some of the most important for transitions.
Absolutely. And I even go further than just having a great website out there. I actually even would advocate for people even to buy the Google ad terms of your name and maybe your city location, or your name and the word financial advisor, because if they go and search that, then you'll make sure that you're at the very top and it's your newest website, it's your current contact information. Make sure we claim our Google business listing, anything like that that we can do so that it does make you more, easier to find. One of the things I've also started to see and make note of is that we're starting to see firms sue each other for recruiting for vice versa, that they're recruiting advisors from each other. So creative planning sued Osaic for recruiting their advisors, and we're starting to see those come up. Edelman has been suing Prime Capital for recruiting its advisors. That I think is super interesting. It's not just that the advisor has done a wrong action, but now they're purporting that the company has done a wrong action by trying to attract that advisor over to the new firm. Can you kind of comment on that? I think it's a really interesting, maybe to me, it felt like a bit of a change. Tell me if you thought it was, and what do these lawsuits kind of tell us about where things are headed?
Definitely, and you've cited a number of publicly available and publicly filed lawsuits and articles about firms that sue each other, and I think it's on point. I mean, it's a new tactic in the recruiting wars, right? Which is funny to me because a lot of these firms are taking from each other and they get mad when they get taken from, and then they are receiving the benefits when they receive the advisors that come. And
Yes, I think it's so hypocritical to, like, be suing each other when you're each doing these things.
it is very challenging to figure out who's in the right and who's in the wrong because every firm I would think would want to add to their either their inorganic growth, I guess you could call it. And you know better than anyone else who which firms are moving and who's suing who. And what's important to understand is that again, there's certain conduct that firms can or can't control. So when big teams leave a firm, that's when you're more likely to get these suits against the firm itself. So I've talked about I've written about a case in Iowa where one firm, essentially took the entire, office of another Iowa firm, and the firm that was left holding an empty office was none too happy, and that's when the whole, allegations of potential, working together to leave at the same time and announcements and bringing those clients over comes into play, and so I think those transactions are in bigger advisor moves, but hopefully that will die down just because, again, it seems like a lot of these different firms are on the different side of the V sometimes when it comes to suits. If an advisor leaves, the firm losing that advisor won't be too thrilled. But then again, they're also out there recruiting for new advisors.
I like that term. They're gonna be on different sides of the V. I can, like, picture the legal documents and such V, such and such, and you're like, "Oh, they're switching places." Are they the respondent or the petitioner? So,
Exactly.
super interesting. I hadn't thought about which side of the V. I like that. I feel like I just, like, got some, like, legal slang.
I try, Shelby. I try. Yeah, and I think
Thanks.
the important things in these lawsuits, I think you figure out what conduct is at issue. Really, like, did someone solicit or did this team conspire to move? And can that be proven? Because a lot of things can be alleged in a complaint. That doesn't mean it's true. And I think that's where advisors and us working with advisors can really learn like this conduct was blessed, this conduct was chastised by a court. And so to understand it's like, okay, maybe we should avoid that, but this seems okay is important because allegations are one thing, but supporting those are another animal into itself.
Yeah, and I wanna talk about, cease and desist. I feel like there's a lot of firms, even the captive, whether it's an RIA or it's a captive broker-dealer, regional firm, etcetera, cease and desist can be sort of, like, sent out on a kind of like a whim, right, or an automatic. It's almost like an automatic thing that people will get a cease and desist. But we've got a lot of advisors who have maybe never been around the court system that much, and that can be really, really worrisome. What should they be worried about a cease and desist? What is it really telling them to do? Talk about that.
That's a really good point because I think a lot of advisors, this is the most important employment transaction of their life. So to get a cease and desist or a demand letter or a threat of legal action when you're also trying to provide for your family and move your business is the proverbial wrench thrown into the engine that no one wants to see. When you get that, of course, you want to get that to counsel right away. And until you get, in generally, and this is a general statement, until you get an order from the court saying yay or nay on your actions, you should proceed complying with the law, which is why you need to work with, the appropriate people to make sure that your actions are appropriate. And that, again, this is why it's important to know, do the firms send out these cease and desist letters or demand letters on the regular for every advisor? I mean, it's not going to surprise me when advisors leave. Most of the time, I believe the former firm will send a letter reminding the advisor of their legal obligations under their contract. And most of the time, advisors can respond saying, I intend to comply with my agreement, no more, no less. And if it accelerates or it gets, further from there, so be it. But it's an intimidating thing. And for those of us who see those all the time, it's another day in the another walk in the park. But for those who only see it once, it could be a heart stopper. So it's important to evaluate, the form and substance of that to figure out, is this just warning me of previous future actions, or have I done something wrong that may be brought to court?
Yeah, I think it's interesting. I think about cease and desist, and I don't know if you saw that I got one recently from a
I,
firm.
I, I saw that on your website. Yeah.
So
Right.
I understand that like moment of panic that can come with getting one, right? And I think somebody early on had said to me, if you receive a cease and desist letter, and this was actually said to one of my clients, if you receive a cease and desist, if you're not doing anything wrong, then there's nothing to cease and desist, right? It's saying cease and desist from unlawful action. But if you're not doing any unlawful action, there is nothing to cease and desist from.
Yeah.
And
And I think
so,
that,
yeah, go
yeah,
ahead.
yeah, that's generally right, Shelby, of course, depending on the actions and the law. But, we also want to make sure that, you follow the law. And sometimes these cease and desists and demand letters come out. And, there's different avenues that a person receiving them can respond with in terms of, does this impinge on free speech, for example? I mean, certain states, we talked about California. California has very active anti-SLAPP laws. And I'm not going to purport to say what an anti-SLAPP law is on this podcast, but, there are avenues to beat those back. And it's important, again, to connect with the right people at the right time to make sure going forward you keep doing what you're doing properly and legally.
Yeah, and I'm just again so grateful to you because until you started talking about the state by state differences, I sort of looked at this as FINRA law and like what's in compliance with FINRA, et cetera. And there's such big differences state by state. And then also, what I also have observed with a couple clients is that their firms will put clauses into their contract that are not even supported by the state law, right? Like they are actually not at all legal in their states, but they are in the contract and often the advisor will sign those. How do we think about that type of situation?
Yeah, well, no, and that brings up a good point about, pre-negotiation of contracts. A lot of the times, as we discussed, advisors 24, 27, younger advisor maybe doesn't have his or her own book, doesn't think they have a lot of negotiating power. But I have to, give credit to Mark Zucri here. He's another attorney in this space. He reminded me one time, he posted about, you have more bargaining power before you sign an employment agreement than you think you do. If you're a junior advisor, you can, for example, list all your friends and family that could be potential clients. If you're able to carve out a book that you can take later, you can negotiate and pare down some of the more restrictive covenants that you have. That doesn't mean the firm will always accept it, but you know it means that you have more negotiating power than you think you do because the firm wants to have you out there as a business developer to drive business in. But don't think that a lot of these contracts allow you to carve out clients that I have a pre-existing relationship with, and that doesn't mean just active clients. That means potentially everyone on your cell phone, potentially everyone you know. That doesn't mean that will always fly, of course, but it's something to think about before you sign that agreement.
Very interesting. I hadn't thought about how we can word those clauses and those carve outs to benefit you as the advisor. I have a client that has a carve out or has had a carve out for friends and family and for people he automatically sourced, right? Or organically sourced himself. Well, gosh, that like really gave him a nice size carve out as he thought about exiting and really wanted to go down the entrepreneurship route himself and start his own practice. Um, Another one had a friends and family carve out. So it was really about how do we identify who was in the friends and family bucket and how do we justify those? And then now I'm wondering if you could have written it friends and family and any referrals from such, right? Like that would be a way of sort of expanding that network just a little bit more that would give you later on if you ever decided to go down the entrepreneurial path just a little bit more room in that bucket of clients.
Definitely. I mean, a lot of financial advisors, you get one client and that client becomes a referral source for 5, 10 other families. And if that's not carved out, that could pose problems in a transition. And what's the worst that a firm could do if you ask for something like that? I mean, say no. I mean, then you're back to where you were and no worse for the wear potentially. So I think, being vigilant before you sign something and not just signing a PDF that's presented to you is really important.
Yeah, and I really want to encourage women, especially to look at these clauses. Sometimes we want to just accept and we want to say yes. I know this was me, especially earlier in my career. And I think that we have to also say, okay, what's going to be the right thing for us long term as people, as humans, but also what's going to be the right things for our family. And I think anytime that we're going through a negotiation like this, we're not just negotiating on behalf of ourselves and our own income, we are negotiating on the future family needs that we may have and the future flexibility needs that we may want. And so, whether you're male or female, I think that approach of just approach it with sort of a bigger lens and in terms of this negotiation and a bigger purpose. Like you're protecting your future family and that's why you're negotiating. It's not just about the dollars and cents today.
You're totally right. I mean, that control is like we talked about. It's a tension between the firm and the advisor, and there's clearly a middle ground there, uh, based on what the firm will give and willing to give. And if they say no, at least you made the ask and you did what you could. But if you don't ask, then who knows what chips you left on the table there.
Yeah, that's great. Well, Andrew, we're getting here to kind of the end of our time together, unfortunately. But I wanted to ask you a couple of things. One is, how can people get in touch with you and any kind of like closing statement that you may have or closing words of wisdom? And then I do have a few little like lightning round questions that I love to ask everyone.
Sure. Well, I appreciate the time, Shelby, and the work you're doing to help advisors launch their own firms, provide a whole consulting service now is really great because I have clients that come to me saying, I want to go start my own firm. And I say, well, make sure you talk to Shelby because I don't know how to help you start your firm. I can advise on your contract, but go talk to Shelby. If you want to get in touch with me, I mean, Google me, my name, my number, 612-334-5022. I think it's important that there's a lot to know that there's a lot of great attorneys in this space, and it's really nice to be part of a community that's kind of on a place that's trying to empower people and empower advisors there. So I appreciate the opportunity, and you're doing great work for advisors and bringing wisdom and insight that allows people to make informed choices, which is I think the most important thing.
Well, thank you, and you too. And I just am so appreciative of the lens of the state law that you have put onto things, and then also the support that you're doing, especially for those RIA members. Okay, so a few lightning round questions. What is a clause that every advisor should be wary of? If they can strike it, they should.
If you can strike it, you should. What's a clause every advisor should be wary of? I mean, I would say the non-service, non-acceptance. I mean, those are becoming more and more popular, but those will cut your book of business out in a transition, or make you pay a lot to get those clients. And those didn't seem to be around a decade ago.
That's an important one. What is something that you would do differently if you were an advisor today? I mean, you and I see a lot of things that are happening across the industry. What's something you would do differently if you were an advisor?
I mean, Shelby, we just talked about it. I negotiate my employment agreement more aggressively before I sign it and not just sign anything presented to me because even if you just dole a sharp edge of a contract or a clause without eliminating it, you've potentially paved your way a little easier when you want to leave and control your own destiny.
Great advice. Andrew, thank you so much. Our signature question: what is one way that you're living an off script life today?
What is one way I'm living an off script life today? Well, I always try to be appreciative for the things I have, which is health and family. And I think something I hear a lot is you don't realize what you have until you've lost it in terms of health. And so, just get out there and appreciate the walks, put the screen down, and just um, go live outside when you can because you never know.
Well, and especially there in Minnesota as the weather gets amazing. I mean, there's nothing more beautiful than the lakes and the summer in Minnesota, I think.
Completely agree. It's a great place to be when it's not covered in snow.
Well, Andrew, thank you so much for being with us today. I really appreciate this conversation.
Absolutely. Thank you, Shelby. I appreciate it.
And to our listeners, if you're dreaming about independence and you're feeling a little bit chained by the contracts, the fear or confusion, this is your reminder to slow down, check out what you're signing, don't sign unless you've gotten legal support, etc. We hope that this was a playbook for building boldly and living off script. Thanks for joining us. See you soon. All right.